All right, welcome back, everyone. It is fall 2021. It's November 10th. It is the Water, Wetlands, and Watersheds Seminar. And today I'm very pleased and honored to have our colleague and good friend, Tom Ankersen, presenting and admit some folks into the room. So Professor Ankersen directs the University of Florida Conservation Clinic. That's the experiential learning arm of the UF College, Levin College of Law's Environmental and Land Use Law program. Tom practices domestic, international, and comparative environmental law with an emphasis on Florida, Latin American, and the Caribbean, but he's worked or taught in over 30 countries, and the work he's done has led to both domestic law reforms and international agreements in Africa and Central America, as well as in the United Nations treaty system. In Florida, Tom works with state and local governments and many nonprofits to try to figure out innovative solutions to environmental and land use issues through law and policy. Here he serves as the Florida Sea Grant's statewide legal specialist. In 2005, he received a MacArthur Foundation Research and Writing Grant to study land tenure and administration in Latin America, and it led to pioneering English language research into the social function doctrine, which I don't think we'll hear about today, but he continues to work on issues of coastal environment, ecology, law, policy, and development. I think that's mostly what we'll hear about today. And kind of what's most inspiring and intriguing to work with Tom is that he has a lawyer's knowledge of the systems that all of our science is occurring in. And so I'm always surprised at the depth of understanding that Tom brings both about the law and the science, and a curiosity to advance both, and also a conservationist's heart. So Tom, it's really nice to have you. The floor is yours.
Well, thanks, David. And thanks everyone for participating, those of you who are listening in on YouTube as well. Yeah, David said it right. I really have enjoyed working with the scientists that I work with and bringing skills that I have that are unique to them, perhaps, but it's important that we all work together and understand both of those systems. So what I'm going to talk about, I'll go ahead and get my screen share going and get that underway. Let me get this over. Okay, how's that look, David?
So far, so good.
All right, next I'm going to go to full screen. Still there?
Yeah, looking perfect.
Okay, so I'm going to talk about something that's been of interest to me for quite some time, really going back to when sea level rise was just starting to be talked about in the policy arena. Of course, it's been decades of discussion in the scientific arena, but it hit home that it was affecting our shorelines, so we began to see, concern taken, and that concern actually bubbled up from the bottom in some ways from local governments and local actors, because it's so immediate upon the shoreline. And what I'm going to discuss is the law of that shoreline as it applies to, or as sea level rise applies to it. And so I'll work you through this slideshow, and you'll see this chart graph picture at the front. You'll see it several times, so it'll start to hopefully find its way into your head without having to look at it. This idea of what's public, what's private, where does the mean high tide line come in, what is an ambulatory boundary? And so I'll go on and kind of explain a little bit more. So as I said, what is an ambulatory boundary? I'll talk about the significance of it. They're not just property boundaries, although that will be the majority of the conversation today. They're political boundaries, they're maritime boundaries, they're regulatory boundaries, and they are property boundaries. I'll give a very brief overview of the legal history of this concept of a boundary that moves based upon natural forces, and then what the law is in Florida, both in terms of the land under submerged, the land under the water, under tidal waters, which are called sovereign submerged lands, and the legal doctrine that applies to that, which is called the public trust doctrine, and then the ambulatory doctrines that apply where those sovereign submerged lands meet private property, which is at the shoreline, and which moves based upon erosion, accretion, something called reliction, and avulsion. And I'll go over what those are. I'll talk a little bit about what are riparian rights, the rights of a landowner who lives along the shoreline, and then some sort of postmodern issues in the sea level rise era, the concept of coastal squeeze, which has both a natural and a anthropogenic significance, how this might affect riparian rights, the concept of the head of tide, and the tidal datum epoch, finally. Hopefully I'll get through all of this. So just so you'll know, we're not going to talk much about it, but ambulatory boundaries are also political. This is the Constitution of the state of Florida, and what you will see is that the Constitution, the boundaries that set the borders of the state are anything but precise. The middle of the Perdido River, where is that? Well, that depends on where the Perdido River is. The middle of the Chattahoochee River, same thing. To the head of the St. Mary's River, where's the head of the St. Mary's River? These aren't legal terms necessarily, although they have to be interpreted legally. And thence to the middle of that St. Mary's River, and perhaps most interesting, to the Atlantic Ocean, and then due east to the edge of the Gulf Stream, or a distance of 3 geographic miles, whichever is greater. So it's actually, in some places in Florida, the edge of the Gulf Stream, which defines the state line. What are state waters, as they say, and that has, of course, significance in terms of our relationship with the federal government as well. And that Gulf Stream moves, it ambulates. So that's just one example. Another example is international borders, and these are all set by something called a baseline. The baseline is set by something called the mean low water. So it's always submerged, and that's to ensure that territorial lands remain territorial lands. But if you come up from mean low water up to the territorial sea, you'll see that everything is set from there. So that's another ambulatory boundary as well. And then there are ambulatory regulatory boundaries, the same ones that we'll be talking about today. And these are the basis of regulation by the federal and state government, and to some extent local governments as well, that some of you may have heard about. But on freshwater, it's the ordinary high water line, which is something that's described by vegetation and soils. And in saltwater, it's the mean high water line. And we'll talk more about that latter one. So just so you know, there is an ambulatory boundary for freshwaters, and that's called the ordinary high water line. And this is the definition of it from the United States Supreme Court. It's ascertaining the presence and action of water that is so common and usual as to mark upon the soil of a bed a character distinct from that of the banks in respect to vegetation, as well as in respect to the nature of the soil itself. So it's then up to you guys, you scientists, to tell us where that is. It's a lot harder to do, actually, than it is to determine the mean high tide line, which is basically the representation, the expression of a physical line, datum on the shoreline. Even since it's not, this class is not about this particular, the ordinary high water line, I would highly recommend this book right here. It's actually an engaging book in terms of the cultural aspect of it, as well as the legal aspect of it and the surveying aspect of it. And it's called Down to the Waterline. It's quite remarkable, and there's a lot of cases that where people are just as important as the legal issues as to how they're resolved and so forth. Oops. Okay, get this somewhere else. There we go. In terms of this line and where it is and how it ambulates, it's basically the distinction between public and private property. And this runs way back over tidal waters. This runs way back to ancient Rome. This concept that the running waters are common to all mankind, and therefore they should not be owned by anyone. And that was from the Statutes of Justinian. That's the Roman code. That code was discovered in the late Middle Ages, and incorporated into the civil law, this other legal system, in addition to our common law, which is All of the countries, most of the countries that derive from England, use the common law. The civil law is this other legal system, but they all go back to Rome. And this concept of the land under submerged lands, and tidally submerged lands in particular for our purposes, are public and subject to use by the public, goes back to Rome, and then it carried through both of these legal systems to the point to today. And today they're expressed as the dominio publico if you were in a Spanish-speaking civil law country, and the public trust doctrine if you're in an English-speaking common law country. And we'll talk just a bit more about that doctrine and what it means in a moment. Okay, well, where'd you go? All right, do it that way. Again, all roads lead from Rome. And the one interesting thing that's diverged a little bit is the Romans saw that the public ownership ended at the highest waves, the point of the highest winter waves, and there was commons beneath that. It was owned by the state, and it was called res publica, and able to be used by everyone. And this was known as res communes, which means common things, public things. And interestingly, Louisiana is a civil law state, although it's sort of a hybrid at this point of civil and common law because of its French background. And they recognize the highest winter waves as the subject as to where the public trust begins. Okay, so mean high water. Mean high water is when in Florida, in the United States, in most places, not all places, but in most states, is where this public trust begins, where the ambulatory boundary is. And it's the average of all the high water heights observed over the national tidal datum epoch, which is an astronomical cycle of 18.6 years when you capture all the tidal ranges around that particular cycle. And then there are examples where, because things are happening faster, too fast, and this comes back to sea level rise going forward, but where places are subsiding or emerging faster, that they do it more quickly than 18.6 years because the acceleration doesn't lend itself to a stable tide line, if you will. So simultaneous observations in a shorter one is the idea here. And the physical representation of this datum on the shore is the mean high water. And so those are all the datums that you see. NOAA sets these datums, and they do it every 25 years. And I'm going to talk about that at the very end a little bit, and to what that might mean from a sea level rise perspective. These datums are set by NOAA, but then they are interpreted locally because the tides are different everywhere, correct? And you can see on the right, this area that is exposed is not always exposed, the sandy beach area. And as you come, this is probably the better example here. There's that map again, right? And here's a definition of the significance of the mean high water line straight from the Florida statutes. It says, mean high water line along the shores of land bordering on navigable waters is recognized and declared to be the boundary between the foreshore owned by the state in its sovereign capacity and upland subject to private ownership. And there it is, the mean high tide line. A couple things are important here. Perhaps most significantly, there's a mean low tide line, so that at some portion of the day, every day, there is what's called a wet sand beach. And then there is this dry sand beach, which is landward, which has been the subject of huge controversy here in Florida over the last few years over basically private property rights. And then you move out and the rest is submerged land. So the public trust doctrine extends to this wet sand beach and means that it's open for the public at all times. So anyone in the public can walk along a beach on the wet sand and not be concerned about trespassing. Think about what happens when you begin to have sea level rise encroach upon structures and suddenly you lose that wet sand beach. Where will those people walk? And that's one of these legal questions that's sort of interesting and confounding at the same time. We've talked about some of this already. So in Florida, the submerged lands are subject to something called the public trust doctrine. And this comes from a history that dates back, of course, to Rome, to England, to the American colonial courts, and ultimately to the U.S. Supreme Court and to the states, the many states. And it's a limitation on the authority of the state to alienate or adversely affect those submerged lands for fishing, bathing, and navigation. Those are the specific terms used in case law in the state of Florida. You can always extrapolate that in order to fish, you need to have good quality water. So you can make the argument that this public trust doctrine applies to water quality as well. The same with bathing as well. And it also gives navigation sort of a superior right, if you will, in terms of how we affect it by making decisions. So you can argue that navigation is a public trust right, and therefore the right to boat on these waters is protected. And that's also an interesting issue area. This is the Supreme Court opinion, which sort of memorialized the public trust doctrine in the United States. Very famous case, Illinois Central. And the key there is that it is without substantial impairment to the interests of the public in waters. Now, that was not the way our history evolved, particularly the early part of Florida's history, when we were on a development trajectory and selling off submerged lands as quickly as we could for both development purposes and for economic, for the state's treasury itself. And then this is enshrined in the Florida Constitution. This has all been sort of tightened up in the more recent past, beginning in the 1970s or so, late 1960s, in terms of how we dealt with these lands in Florida. Ambulatory boundaries. So we go back to this idea that there's a line in the sand, quite literally, but it moves. The line itself does not move, but what moves is the sand and the water underneath it. And that's probably something to understand too. So that's just a plane along the a horizontal plane that intersects with the slope at some point is the way you would describe that. But because of erosion and accretion and tides, it seems like it's moving. The doctrines that apply to it in terms of how it changes are avulsion, erosion, accretion, and reliction, artificial avulsion, accretion, riparian rights, and customary use. And so I'm going to spend the rest of the time talking about these. Avulsion is one I won't spend as much time on, but it essentially means that I'll just continue on here and hope these animations work. So here's, again, an expression of that area, that boundary. You can see the wet sand, you can see the dry sand, you can see where the mean high water line is, and you can see what's called the line of vegetation, which is important. It's particularly important in Texas, for example, where the people actually have a easement to use the dry sand beach, something that doesn't exist in that form in Florida. There's another doctrine that applies there. But in Texas, up to the vegetation line, you're allowed to use the dry sand beach. Okay, there we go. And here come the people, and there's this idea of a prescriptive easement or customary rights, which may exist, and that's what's been at issue in Florida of recent. All the beach access issues have centered around this question of whether people have this long-standing right to use the dry sand beach, even though it is not publicly owned and not subject to the public trust doctrine. And then the question is it, so when change happens, you see there the old mean high water line. I'm not sure the animations aren't working quite as well as I was hoping they would. But when change happens, it can happen two ways. It can happen right away, suddenly, as in a hurricane. You'll have this huge wash. It'll take out huge chunks of the beach, or it'll happen slowly and imperceptibly. If it's sudden and perceptible, you can see it, and it happens overnight, it's called avulsion. When there is an avulsion, the property boundary does not change. That is, the private property owner would continue to have ownership of the submerged lands that were avulsed. That can that private property owner has to act on that over a period of time, or it will revert back to the state. But that's the rule of avulsion. And it goes the other way too. When a huge swath of sand gets sucked into an inlet and changes what the composition of the property on the interior, and it's suddenly all sand and dry, that may still be submerged lands. That will still be public lands. That still may be the state's lands. And this is the erosion concept. Now, that was my effort at animation, so how great that was. But in any case, and here's an example of it playing out in law. And this is kind of a classic. Here you have some lots that are on the Gulf of Mexico, and you can see where on the top left, you can see where the mean high water line was before 1950. And you can see that erosion is going to start happening. And in 1953, again, this was pretty fast, but it may have been the result of some work being done elsewhere, which we'll get into in a moment as well, in terms of how that people that working on putting up structures and so forth away from your property affect your property when it changes the way things erode and accrete. But you'll see here that lots 1, 2, and 3 are gone, and they stay gone. They're not coming back. So you've lost that property completely because it eroded all the way back behind those lots, and now it has accreted all the way back in that bottom left picture. It is accreted all the way back and just absorbed, if you will, those first 3 lots. And that's tough luck, is I guess the best way to put it from the property owner's perspective. And so that's one good example. And there, oh, okay. How's that? Here's another one just for, to reinforce that. This is again in the Sarasota area. The Gulf beaches are very dynamic, much more so than the Atlantic. Their dunes are less stable. And so you see a lot more of this, and people would build closer, I suppose, too, in some cases. So here's some property. Take a look at those. And now look, they're underwater. So all these people who bought these lots, they're out of luck. So one thing that one doctrine that has significance beyond avulsion, erosion, and accretion is something called the customary use doctrine. And this is the right of people to use the dry sand beach. And this was found to be the law in Florida in this 1974 case. And it basically said that if the recreational use of the sandy area adjacent to the mean high tide has been ancient, reasonable, without interruption, and free from dispute, such as a use as a matter of custom should not be interfered with. And each of those terms has to be proved in the court of law: ancient, reasonable, without interruption, and free from dispute. And there's considerable discussion around that, and there's subsequent case law about that, which said you can't just throw all the beaches of the state open under this doctrine, which is what the state of Oregon did in one single case. You have to decide it case by case by case. And so that's caused the private property rights issues that have been at the forefront of beach access over the last few years. And the legislature stepped in, passed a very process-based statute that hasn't made very many people happy either. So that's another lecture. Riparian rights. So riparian rights are significant. If you own property on the shoreline, then you have certain rights that other property owners don't have, that aren't on the shoreline, and they have been held to be property rights. They extend out beyond your property. And they travel with the property, whether they're mentioned in the deed or not. And they include access to the water, so that you cannot be denied access to the water, an relatively unobstructed view of the water. And that's one of the things we have students looking at in our coastal policy lab this semester is what does that mean, and how can we deal with that question when we want more mangroves on the shoreline to prevent erosion and to increase sedimentation and to add ecosystem services when property owners want to be able to look out and see the water? So that's sort of this interesting policy conundrum that we're confronting. And then the right to wharf out, which is the right to build a dock. So you have that right as a property owner. It can be limited. And so typically there's an exemption in our statutes, which says you can build a dock, but it can only be 500 square feet and you can't affect the endangered species and so forth and so on. And importantly, as a riparian property owner, you have the right to accretion and presumably the right to erosion. And you would think that nobody would want the right to erosion, but in point of fact, there has been cases where that's been true, and I can, if I have time, I'll describe that. But in any case, so that's you have the right for the land that accretes in front of your property line to be your land and to move your property line, hence the ambulatory boundary. So I think I'm doing pretty well on time, David.
Yeah, I got about 25 minutes.
Okay, well, I'll take 10 or so of these, talking about some of these interesting issues that come up in as a matter of sort of policy and law, and then we can take some questions if you wish. So here's our postmodern beach, and one of these issues is coastal squeeze, and coastal squeeze is this idea that as this property line ambulates, as it moves landward, it's going to run into something at some point on most developed shorelines. It's not as big a problem, of course, when you have natural areas on the coastline. You have basically migration happening of the ecosystems and the species inland as that happens, if it's slow enough and over time. But what happens when you get structures? You both affect the habitat, right? You affect that riparian habitat, which has nowhere to go, and you affect the ability of people to use the beach to recreate on the dry sand, on the wet sand beach, even because at some point the wet sand, the difference between the mean high tide line and the mean low tide line is going to be, some between these 2x4s there that are tacked to that seawall. So it'll be vertical, and you'll need some suction cups or something to walk in the area that, as a matter of the public trust, you are entitled to do. So there's some question about whether or not the public trust is being violated when seawalls are being put up to protect property, if they are not. If the ultimate conclusion is going to be in a sea level rise scenario, that there's always going to be erosion and you're not going to get accretion. The policy default to deal with this has been beach nourishment, right? And so just briefly, what beach nourishment does is it allows the government to come in and add sand seaward of the mean high tide line. And as a result of that, they've avulsed, essentially. They've created this new land that is public property. And what that does is it takes away the property, it takes away the private property landowners' ability to touch the mean high tide line. When they can no longer touch the mean high tide line, in theory, they no longer have riparian rights, because those rights attach when you touch the mean high tide line. So what the state has done in order to facilitate beach nourishment, and about half the beaches in Florida are now nourished, what the state has done is first thing it does is it fixes the property line at the mean high tide line. And it calls that the erosion control line. That becomes a fixed line. It's no longer ambulating. Everything waterward of that is publicly owned and publicly accessible for recreation and so forth. Everything landward remains privately owned, and the riparian rights are preserved. So that's the default policy to deal with that issue and to deal with coastal squeeze. It doesn't necessarily deal with the habitat issues that we have, because all you're getting is the sandy beach habitat, and that has to be renourished every so often in order to keep up with it. So how long we can continue nourishing our beaches remains to be seen in the face of sea level rise, but that's the path we've taken. Okay, I guess I have to go back over here again. So here's another manifestation of that would be of interest to some of us in particular. And this is when you construct a living shoreline. The rule is, the legal rule is, and this is what we call artificial accretion, is that I'll just read this quote here. The fact that such accretions or relictions occurred in part because of artificial improvement does not affect the owner's title to those lands, provided the owner has not constructed improvements which cause the accretions. Well, that's exactly what you're doing when you're building a living shoreline. You are constructing improvements to cause accretion. You want sedimentation, sediments to come in, fill in, and get marsh grasses and hopefully hold back erosion. In so doing, you're doing the same thing that was happening as I described earlier with beach nourishment. You're taking the, you're removing the private property owner's ability to touch the water from their property, because everything you've added, because it's artificial and you've done it to yourself, is publicly owned in theory. So even if it's 2 inches, you get 2 inches of accretion beyond what was the mean high tide line. In theory, that remains the state's. You no longer touch the water. Therefore, your riparian rights are no longer in place, in force. So how do you deal with that? Well, there's an easy remedy for that, the same one that they've done with the beach nourishment, which is to have the state grant those riparian rights through the permit. In this case, is one way to handle that one. But it's an interesting little piece of the puzzle here as we move forward with sea level rise and property boundaries. Okay. Here's another one that's kind of fun to look at, and this is like, what's it going to cost? What's it worth? So this is the former PhD student whose committee I was on in geomatics, did some work on this issue in the Sarasota County area. And he just looked at, what happens to property values in an eroding situation, because the way they usually, an empty lot would be based upon the square footage, and you would have a value per square foot. And that value would be what you would be assessed at, and that's how you would pay your property taxes. So if that property is eroding substantially, then the value is also eroding, I guess is one way to put it. I mean, it may also be going up for other reasons, but it's eroding from this assessed value standpoint. And the state coffers, the property county coffers, are being reduced by some amount. And here it's over $1,000 over the course of this in this crosshatched area here, which is just an interesting aspect of this as well. So another interesting concept, which again is a scientific concept, the head of tide. The head of tide is where you stop seeing any tidal influence in an estuary or in a river that feeds into an estuary. And so once you get to that point, you are no longer tidal waters. Therefore, you're no longer calculating the mean high tide line or the mean high water line. You're switching over to the property boundary. And so in sea level rise scenarios, presumably the head of tide is going to be moving upstream, and how property is determined, where the property boundary is determined, that ambulatory boundary is going to change with it. What the impact that might have on a property owner is, I couldn't tell you, but it's an interesting piece of the question. And then finally, this idea of the national tidal datum epoch. So every 18.6 years, they average all the tides and so forth, and bring sea level rise into the equation, and they recalculate the epoch, and that serves as the basis for establishing all of these boundaries over time. And we're now at the end of one epoch. We're kind of an epoch behind each time. So we're working with this 1983 to 2001 data set. NOAA in some little basement somewhere up in DC, these guys are crunching numbers, and they're coming up with the next tidal epoch, which they're going to release by 2025. The interesting question is, how is accelerating sea level rise going to affect this? And will there be jumps, if you will, in these datum such that it also affects property boundaries? And then the question is, how big is that effect? And so my colleague, Mark Clark here, crunched some numbers and did some things for Cedar Key, looking at this. And basically he didn't do all the number crunching that's going on in in Washington, but he just made some effort to estimate what the epoch might look like for the next iteration. And he concluded that we're going to see a difference here in mean high water of 2.8 inches. So this is not, I'm not sure how best to put this, but this is a sudden jump, I guess. And then you'll calculate mean high tide. So that's going to happen in an increasingly rapid pace with what's called sea level rise acceleration, which we see in graphs. So it may be, I'll go to the next slide here. Here's Mark's calculation of what it might look like in terms of a sloped shoreline based upon those numbers. And this is the horizontal shift that will result just from the day after they announce a rule in Washington as to what the national tidal datum epoch is. So this is his idea of a shift in feet based upon those numbers that he calculated previously and what effect that might have on the property boundary from a regulatory change, because it's basically a regulation is when they set this epoch. So, and I think that is it. So David, take it away. Should I stop sharing?
Yeah, well, I think we may want to go back to, well, why don't you go back to the last one for a second? I'll just sort of ask a question there. So yes, let's give a round of applause. Thanks to Tom for speaking with us today. And I love the terminology from the law side, and, like it's got to be ancient and, by common practice, the number of terms that you guys can interpret is, or can't interpret, I guess, is kind of.
We can argue over. That's what that's what interpret means.
So here, I mean, just to make it clear to everyone, like the shoreline boundary in a place like Cedar Key, if you got a property that doesn't have any protection, is probably much closer to like the 1%, 5%, 1%. So if you get a shift of 2.8 inches in the mean high water line, 23 feet of your shoreline become, and Tom, this is the question part. So let's assume this 23-foot shift becomes under this jurisdictional line, the mean high water line. That land reverts to the state. Is that how it just occurs, or how does that?
Yes, I think that's the case. Maybe we ought to adopt the term. Well, I'm not sure we want to do that, but the term regulatory avulsion, because it's really happening as an overnight. And that's why Mark was suggesting, and I think rightly so, that they may need to start thinking about calculating these things on shorter time horizons, even though you're not getting the astronomical cycle. And that's done for Louisiana because of subsidence. And I think also in Alaska, so they do it on 5-year cycles.
All right, thanks. And Kathy,
I wish Mark were here, because I'll be the first person to tell you I haven't totally wrapped my head around all these tidal datum issues. So,
Kathy, go ahead, and then we'll have Liz.
Tom, what happens when a shoal develops in a river or offshore so that it's not connected to the land? Is that automatically belong to the state?
Yes. Yeah. Yeah, if a shoal develops, it will remain state, because it was surrounded by state water, state lands anyway.
But if it becomes a peninsula, then that automatically accretes to the owner of the shoreline. Yeah,
there's some interesting examples where people's property just grew and grew and grew, and sometimes they don't even want that much, because there's owning property has its own problems with it, right? But yeah, that's true.
Thanks. Okay, go ahead, Liz. If you're speaking, you're muted, Liz Penrod. All right, she left the room. Okay, no question there. All right, let's see. Go to YouTube for a second, see if there are any questions over there. All right, none so far. So this idea that that you can gain and lose. Like, do you, as a landowner whose property is accreting, do you have like the responsibility to acquire that land, or can you say no? Can you pass?
No, I don't think so. I mean, that's an interesting question. I think it's yours whether you want it or not.
Yeah, that's a sort of a strange outcome.
Yeah. So the other interesting aspect of this artificial accretion is if, for example, when they do a beach nourishment project in St. Augustine, inevitably that sand drifts down and
Contributes
to beaches to the south. And so those property owners gain that sand, assuming that those to the south have not been nourished. They gain that sand, and so their property grows because they did not cause the artificial erosion. But in the case where you put up some sort of a structure to prevent erosion, then you would lose the sand. That you would not have ownership of the accreted area.
So is the idea behind that, like if I've got a shoreline property, I want to build a living shoreline to protect my, from waves and storm surge and whatnot. But that I could also, let's say I was a coastal developer, I could, hey, I'm building a bunch of living shoreline and you're just with the intent of increasing your property boundary.
That's correct. Yeah, it's a sort of an unclean hand sort of thing, which is one of our legal terms. You're helping yourself.
But if you, for example, were had a really good coastal geomorphologist on your staff, then you could figure out whose properties sort of up gradient, sediment gradient should be protected to provide, and you could then let's say lobby for those groups to build natural shorelines or living shorelines or do some kind of accretion. So you can potentially game the system like that, as long as you didn't pay for the project or it wasn't on your property. Could you pay for
Well, I mean, if it could be traced back to you as the person who did it, then yeah. I mean, I suppose if you had knowledge of it, you could, you can say this guy says, hey, I'm going to do this and it's going to increase your property and therefore I want some money or something like that. Then I think that would, the court would look at that and find that you would help yourself just like somebody who did it themselves.
Right.
Nice try.
Yeah, well, that's why I need a lawyer. Okay, so any other questions from the group? All right, well then let's give one more round of applause. Thanks so much, Tom, for joining us today.
All right. That was fun. It's nice putting together several PowerPoints put together and thought about differently. So
yeah, well, you took us from ancient Rome to the future, and
yeah, that's true.
Yeah, so we really appreciate it. All right, folks, let's see. Next week, yes, we'll see you back here next week for the next seminar. Until then, be good yourself, be good to